Hello, friends. Today on the show, we are very lucky to have an honored guest, Miss Isela Simpkins, estate planning attorney from Orlando, Florida. And of course, our friend of the show, Miss Irachicolo Morales, who's normally from Orlando, but is sitting here in our Miami offices today. We're so happy to have you both. Welcome back to the Divorce Broadcast. My name is Manny Segarra, coming to you from Miami, Florida. So, Miss Isela Simpkins, our honored guest, can you tell us a little bit about you and what type of law you practice?
Yes, so I practice estate planning. What does that mean?
Yes. Well, that's going to be the
Estate
second part, but first, tell us about you first. We're going to get to all that in a second.
So right now I practice estate planning. I've been an attorney for 10 years. In that time, I practiced criminal law, a little bit of insurance defense, and now I'm practicing estate planning. I graduated from Stetson Law in 2014, and I practice mostly in the Orlando, Florida area. So I serve most Central Florida, but I'm able to serve anywhere in Florida because I'm a virtual office. So all of my meetings are virtual except one meeting where I send someone or I attend in person to get everything signed and executed.
Very cool. And before we get on the show, you saw your fur baby, the cat, walk by, but you also have a husband and a small child, right?
Yes, yes. My husband Kyle and I have a baby boy. He's 13 months, Arlo.
Oh, cute.
And then we have another baby on the way who's due in December, January-ish.
Very cool. All right, Miss Irachicolo Morales, back in town from Orlando. How have you been and what have you been up to?
Hi, I'm so happy to be back. Oh, what have I been up to? Well, recently I've made a hobby out of wedding planning. I do have an upcoming wedding, so yay me.
How exciting is that?
Yes, I'm very excited, very stressful. But aside from that, it's been very busy. I've been up in Orlando, but I'm really happy to be back here visiting you guys.
Rumor has it you were in mediation for a couple hours last week. How long were you in mediation for?
Oh, wow. Yes, I think it was about an 11-hour mediation on a Friday night too. So that's what I did all day.
Those are your Friday plans. Well, being such a diligent worker, I think you were able to finally knock out a settlement. So congrats to you. All right. So today, Irach, what did you think when you found out we were going to have an estate planning attorney on the show?
Well, I thought it would be perfect because a lot of times they do have a lot of crosses in a sense. So sometimes I get asked questions that are mostly for an estate planning, and I'm sure Isela sometimes get questions that it's for a family law attorney. And although they are two different realms, they do cross a lot and each one does affect each other. So I thought it would be really interesting to kind of show you the pros, the cons, and some of the things that you need to watch out for when you are entering a divorce, post-divorce, and considering your estate planning.
Very cool. Okay. Isela, nowadays you indicated that you are practicing exclusively in estate planning, and you had indicated during your intro, you had asked, what is that? Well, that's a heck of a question. Can you please tell the viewers what estate planning is?
Yes, as simple as I can possibly make it, estate planning is about what happens to your things if something happens to you. So if you are, let's say, like you're in an accident that leaves you incapacitated, physically or mentally, and then also what happens to your things after you die. So who gets what? When do they get it? How do they get it? Do they get it a little bit at a time? Do they get it all at once? And then also what I work on the most, because I work mostly with families with kids under 18, is what happens to your kids, how they're provided for. And then another part of estate planning is who makes decisions for you if something happens to you. So essentially, estate planning is all about planning for the future.
Very cool. So we're going to break all of that down. Isela, do you ever run into some pushback from people? Because I know some of these topics are a little bit uncomfortable to think about or to talk about. No one really wants to think about their own demise or what would happen to them. Can you tell the audience how you address that part of it?
Yes, people don't want to think about their own mortality. Obviously, it's not a comfortable topic. There's consults that I have where there's tears involved, and that's completely fine. It's an emotional topic. It's an emotional situation. You're making decisions. My biggest goal is for my clients to understand if you don't think about that, the state of Florida has thought about it for you. So if you don't make a decision and something happens to you, the state's going to be like, okay, well, this is what we're going to do.
Right. So all the more reason to plan ahead. Irach, I'm sure we run into some of that pushback when people talk about divorce, right?
Yes, we do. Nobody likes to talk about uncomfortable topics, but that's what we're here for.
All right, so let's talk about estate planning. What are some of the common documents that you would prepare for somebody?
So I typically draft 4 to 6 major documents for the clients that I meet with. So that's trusts, wills, power of attorneys, guardian designation, especially if you have kids. I also work with designation of healthcare surrogate, and then advanced care directive or living wills, which are end of death documents. So those are the ones that I mostly work with.
Very cool. So let's get into the first one, at least that we'll talk about on today's show, which is trust.
Yes, and I find a lot of people have heard the word, but they don't really understand what it means, or think you have to have a ton of money to have a trust. A trust is essentially like a contract that you make with yourself.
Really? Is it like a New Year's resolution where you contract with yourself to get in better shape, or is it a little bit more complicated?
Better financial shape, right? So,
Okay.
so you make this contract to put stuff in the trust. And then depending on what trust you decide on, usually the ones I work on the most, you are the person that's in charge of managing the trust. So really nothing changes unless something happens to you and then you picked a backup to keep managing what you've put in the trust for you and for the benefit of whoever you've decided is on there.
Now, Isela, I thought that was a really cool explanation of what a trust is. Is there different kinds of trusts?
Yes, there's a lot of different kinds of trusts and they all do different things. So the one that I just described, that's a revocable trust. That's the most flexible trust. That's typically what people need, especially if they have kids under 18, because you're moving stuff in there and you can do whatever you want with it while you're alive, and then you can leave instructions for what happens. There's other trusts like irrevocable trusts. Those are very restrictive. You, like the word says, you cannot revoke them unless the court says that's okay. So that involves the court a little more, but it gives you more benefits. Like it protects you from creditors, it protects you from lawsuits, it protects you from a lot of things, but you lose control over your stuff. You also have special needs trust, which would be if you have a child with special needs or you yourself have a special need and you want to qualify for government benefits, you can put some of your assets in there, some of your things that you want in there, so that you qualify for benefits that have like income limits or asset limits. There's other trusts like charitable trusts, Q-tip trusts, life insurance trust, testamentary trust. They all do different things, but those are kind of the main ones, the ones that have.
That's very, very cool. So, Isela, can you give us an example of something that you would put in a trust and how the mechanics of that would work?
Yes. So you can put whatever you have in a trust, but for a lot of people, it's going to be like, for an example, a house, like your house. You can put your house in your trust, and then you can leave instructions for what happens to your house after you die. Do you want it to stay in the trust? Do you want it to be sold and distributed? Maybe you have a rental property and you want the rental to continue so that whoever you want to keeps getting that money from that rental. You can leave life insurances to the trust, retirement accounts. The way it will work is depending on what you're moving. And it also depends on, which I hate to say that, right? I feel like as lawyers, we say that all the time. It depends. But if you have like minor kids, you have to move things a certain way. If you don't have minor kids, then you have more flexibility. If you have a spouse. So all these things are taken into consideration when you meet with your attorney, and then they can tell you, well, this is what you need to do. This is the type of trust that you need. But usually the house is the biggest thing that people are moving into the trust.
Interesting. Thank you for articulating that question before we give away the secret sauce. What makes a trust different than, let's say, a will, for instance?
The biggest difference is a trust gives you more control over how your stuff is gonna get distributed after you pass, and you can actually leave instructions for what happens to your stuff if you're still alive, but you can't manage it anymore. A will is a simple after death, and it gives you less control.
Interesting stuff. All
And
right.
wait, actually, I forgot one.
Okay.
The court involvement. So the will has to go through court after you die. The trust doesn't.
Ooh, that's a big one because
Good one.
usually court costs a lot of money, right?
Yes.
Yeah.
All right. Reg, how do trusts kind of play out in divorce cases, at least in your experience?
Trusts are a very complicated, I guess, process because you can make it whatever you want. In the divorce, it's just interesting. A lot of people tend to want to use trust as a way to keep it out of a divorce, right? Because in their minds, they're thinking, well, I have this property and maybe I want to give it to my son or my daughter, and maybe I don't want to give it to my spouse, right? So a lot of times what they try to do is they put the property or a property that was purchased during the marriage in a trust, thinking that it will be excluded. But as we've discussed in other shows, we all know that a marital asset is something that was purchased or acquired during the marriage and prior to the filing of a petition for dissolution of marriage. So for that reason, if there was marital monies that was used to acquire this property, for example, it's not an automatic exclusion regardless if it goes into a trust. So that's some of the things that the court will need to unravel and things that we usually have to explain to clients to understand that thoroughly.
Very interesting. So just because you create a trust doesn't mean you can't hide it from the family court, right?
That's correct. And we know family court is, it's very intrusive into your finances. So it's difficult to hide it.
Okay, so this question, I guess, would be posed to either one of you. What happens to a trust when somebody files for divorce? Who wants to take that one?
So if somebody files for divorce, the trust remains until the end of the divorce. So when that final order is entered, that's when the trust changes and kind of pretends that your spouse is dead. So everything that was about your spouse in there is essentially gone. For clarity, you should still update it because also there's probably some other stuff you're going to want to change. But during the life of the divorce, the trust is still there. So if you file for divorce on Monday and something happens to you on Wednesday, trust is still valid.
So what do you think of that, Iraj? I think that would surprise a lot of people knowing that if you file for divorce, your soon-to-be ex-spouse still gets to be a beneficiary of that trust until the entry of a final judgment. Any thoughts about that?
Yeah, that's correct. And it's not just, we're going to go into a little bit of the other items that also need to be modified. But the difficult part of that, right, when you enter a divorce is that a lot of times you can't modify it unless you get court approval. So it's super important that even though you filed for the petition, it doesn't mean you have no recourse, right? It's all in the hands of your spouse. You do have recourse, but it does take a little bit of time to do it. So you got to start thinking about this before the divorce starts.
Very cool. Isela, what about if it was an irrevocable trust? Do you think that that would make it a little bit more challenging to modify or change in the event of a divorce?
Yes, either two things. Either you need to include what's going to happen with the trust after the divorce in the order so that you can change it because like I said, the irrevocable trust require court approval to get changed. Or when you're drafting the trust, you need to put in there, in case of a divorce, this is what happens to this trust. So those are the options. But like when you're drafting a trust with your spouse, no one's thinking about, well, if I get a divorce, what's going to happen to this trust? So the first option is what ends up happening. You have to include it in your divorce judgment in your final orders.
Sounds like a practice tip. Make sure that if you are creating a trust that you put in language regarding what happens in the event someone files for divorce, huh?
Yes, and nobody wants to do that.
It's a little bit awkward. All right, turning on to the next topic, and that is the creation of a will. To will or not to will? Why are wills important, Isela?
Wills are important because this is the document that you draft when all you want to do is say who gets your stuff after you pass away. If you have kids under 18, you're also going to put your guardians on there. So that's also very important. If you don't do a will, then you're considered intestate, unless you have another tool like a trust, for example, which means if you don't have a plan, the state has a plan for you.
Oh, and I don't know about either of you, but sometimes the plan by the state is not as good as the plan in my own head, or I guess in our own heads.
Yes.
What happens to you, Isela, if you die without a will and are married?
If you die without a will and are married, it's going to depend on your spouse is going to get everything. But again, if you have minor kids outside of your marriage, then those kids also need to be considered in that distribution. So your kids and your spouse are always protected, especially when it comes to your house, which I think we'll talk about a little later also.
So let's give an example. If you are, I guess for those people that like to do the second time around or third time around marriages, those are some of our best customers, right, Rich?
Yes.
When they get married, they have children from a previous relationship. They get remarried and now they pass away while they have a spouse and or a spouse with children in their new marriage. What happens in that type of situation, Isela?
Usually, if you have children from a prior marriage and you've been through a divorce, like Rich can probably expand on this, you have a life insurance policy that is going to go to those kids. Is that right, Rich?
You would hope you would. A lot of times there is one in place if there's, child support obligations or something that was agreed upon, but sometimes there isn't.
Isela is thinking of all the nice, benevolent people in the world. Rich and I are on the wrong side of that because a lot of times when they get divorced, they don't necessarily plan for, the eventuality of passing
Oops.
away or having an insurance policy. So,
Oops.
yeah.
That's like the first thing I ask my clients when I sit down with them. Do you have insurance? Do you have insurance? But like for example, with your primary house, your homestead, if you leave a spouse and kids from a previous marriage, what does that mean? That means that your spouse will get, and these are minors, will have a life estate. And that means that they can live in it for the entirety of their lives. When they die, then it goes to your kids. Or they can choose to cash in the house and then they get 50% of the house, the value of the house, and then your kids will get 50% of the value of the house. And then the rest of your stuff is going to go to your spouse. Hopefully your life insurance is going to go to your kids because you thought ahead.
Wow, Rich, I know that you and I were both surprised about some of that. The home, especially the homestead exemption.
Yes, the homestead. It's a constitutional right, in Florida. So you cannot just automatically devise that away.
When we say devise, just for clarity, you can sell your house while you're alive to whoever you want. There's no restrictions on that. But when you die, you cannot leave it to anyone other than your wife and kids.
Can you explain what a life estate means?
Yes, a life estate is a right to own that property for your life.
So that means that spouse gets to stay there for as long as they shall live.
Yes, as long as you live. But it also, nobody wants to buy a life estate, so it restricts that spouse a lot. No one wants to buy a house just for however long that person's alive. So that's also gonna mess up the spouse that's still alive.
I hear you. So what happens in the event that a divorce is filed, Irech, and there's a will? Does that will automatically get annulled or vacated?
No, it doesn't, unfortunately, unless you are going to modify it, right? It will usually only terminate, and Isela mentioned this earlier, once the final judgment or that piece of paper that says you're divorced, that's when it'll go away and it'll act as if that person has essentially died, in a sense.
That's a tough one for some of our viewers who are going through the divorce process to kind of hear, knowing that any will that they have right now is still in effect. Tough stuff, tough stuff. Okay, so we're going to keep moving on now to something that I find fascinating, and that is the health care surrogate. That is something that is also an estate planning device. Is it not, Isela?
Yes. The healthcare surrogate is like a power of attorney, but for your healthcare decisions. So while you're fully coherent, capable, conscious, are going to name somebody to make healthcare decisions for you if something happens to you and you can't make them for yourself.
So this breaks down to some of, I guess, with the rise of dementia and Alzheimer's and things of that nature, it definitely covers that area, Isela?
Yeah, it's going to cover that area, definitely. But also, if you have multiple kids and maybe you trust one of them more than the other, and you're in a car accident and you're unconscious, they can step in and make the decision, and you've already decided that's the person that you wanted.
Very interesting. In terms of who you can assign as your healthcare surrogate, does it have to be your spouse or can it be anybody?
It can be whoever you want. But if you don't want it to be as your spouse, you especially need to have that document because the default is your spouse.
So this is where things are going to get interesting, Isela. What happens if you're going through a divorce proceeding and all of a sudden you realize that your healthcare surrogate is the soon-to-be ex-spouse? Does the filing of a divorce automatically get rid of that healthcare surrogate?
No, unfortunately, it doesn't, unless it specifically provides for it or has some kind of language or terminology that has it's contingent upon a petition of a filing for dissolution of marriage. The divorce will have no legal effect on that surrogate. So for those that are in the middle of a divorce and you know that you've previously executed documents giving your spouse the ability to make healthcare decisions for you when you are not able to, you should think twice because divorce gets pretty petty and you don't want anybody, making decisions for you that no longer have your best interests at heart.
I always jest that the scene from Talladega Nights when
Ricky
the wife
Bobby.
is trying to pull the plug on Ricky Bobby and he has like superficial injuries.
I want the plug pulled.
It's kind of on point though, right? If in this type of situation, one of the spouses is really ill or sick, the soon-to-be ex would have that power. So how do we avoid that? I know that Irech alluded to that, Isela. Can you please tell all of our viewers who are now very concerned about their health and safety. How do we avoid having the spouse be the one who determines whether or not to pull the plug or provide medical treatment during a divorce proceeding?
You need a new one. You need to revoke the old one and draft a new one. And this is the part that people forget. If you've given that document to your doctors and you have a new one, you need to make sure they have the updated one because they're going to act on the one that they have. I say this all the time, especially with financial power of attorneys. The first call needs to, after you file that paper and talk to your divorce attorney, first call needs to be to me. Hey, I need a new healthcare surrogate document. And then as soon as you have that, you need to distribute that to all the people that had the old one.
I think that's great advice. All right, moving on next to another concept called a living will, which is a little bit different than the will that we had just mentioned. Is that right, Isela?
Yes, yeah. So the living will is going to work with the healthcare surrogate document, but this one specifically end of life wishes. So this one says, under what circumstances do you want to them to continue to give you treatment when it's end of life care? So you're in a vegetative state, you have a terminal condition, and there's no chance that you're going to recover. So you're going to choose if you want to continue to have your life prolonged artificially, or if you want to be left to die and given hydration, if you want to be left to die and given pain management, food. So you would go through and decide all of that.
Ooh, those are tough subjects to talk about, Isela.
Those are tough.
It's a little bit uncomfortable. Irech,
Yes.
I'm afraid to ask you, what happens if someone files for divorce? Please don't tell me it's the same thing as a healthcare surrogate, or is it?
Yep, it's the same exact thing. Once you file for the divorce, if you don't want your soon-to-be ex-husband or ex-wife to make those decisions for you, then you need to either make a living will, a new one, in order to modify those terms.
So, Isela, can you account for this when you initially make those living wills? Can you say in the event of a divorce proceeding, maybe you don't have to wait till the final judgment, or is this something that you're just kind of stuck with?
So this one's a little different too, because you can have an agent, which is where it would happen, like Urech said, you would have to wait till the final judgment or amend it. But sometimes you don't need an agent because you're making all the decisions ahead of time. So if your spouse is enemy number one now, maybe your sister has it and can give it to your doctor.
Have copies of it. Okay, sounds good. Moving on to the next topic, we're going to talk about durable powers of attorney. These are very well known in the divorce world. Go ahead, Isela, tell us what a durable power of attorney is.
This is a document that you use to pick someone to manage your finances for you if you can't do it yourself. But this document is effective as soon as you sign it. So with the other ones I said, if you're incapacitated, if you can't make the decisions for yourself, this is effective as soon as you sign it. So that person that you pick first, that person's going to have the same ability to do anything you can with your finances, including opening bank accounts, closing bank accounts, buying property, mortgaging property, everything. So you need to make sure that you pick the person that you trust most, which is usually your spouse, which I'm sure Urech has something to say about that.
That seems like a lot of power to give to somebody, Isela. So Urech, durable power of attorney. What happens if someone files for divorce? Is that automatically revoked or does it remain in effect?
So if the actual agent for that power of attorney is your soon-to-be ex-spouse, then upon you filing for the divorce, it does automatically terminate. So that is a plus. That is a positive sign compared to the other documents.
So this is the first one that we found that automatically kind of terminates upon filing of a divorce. Okay. Isela, can you help at least the viewers and perhaps Urech and I understand a little bit as to why you believe that this durable power of attorney is different than the other documents and is effective upon someone simply opening the case?
Well, I think it's the immediacy of it. So as soon as you sign it, like I said, it becomes effective. So if whoever you name has the same powers that you have, whatever powers you have, they have. So I think that with the other ones, there's that little caveat in there that's like, if you can't make the decision yourself, if you're incapacitated, if you passed away, this one's immediate. So that is, I guess, a protection that the legislature has given.
It does.
Urech, you don't think that a spouse would run off with that durable power of attorney in the middle of a divorce and try to do something that might be either a little bit shady or fraudulent?
That's exactly what I think. A lot of times, even without having a power of attorney, they do it. So you can't imagine if they have a piece of paper paper that would give them the authority or the ability to misappropriate funds or to transfer property or assets out of the other spouse's name to try to hide that from the marital estate when going through the divorce.
Very cool. So I got a two-part question. Isela, for the durable powers of attorney, what do they allow people to do with respect to litigating on behalf of somebody else?
You can set up your power of attorney to give them that authority to allow you to sue or to collect settlement, to defend. That is incorporated in there. That's one of the general grants of power. So a lot of weird things that they do, like you can also pay taxes, collect taxes, but you can allow somebody to sue for you, so they can sue for divorce for you.
There you go. You segued into part B of my question. Iraj, have you had experience in which people have durable powers of attorney and use them to litigate divorce cases?
Yes, it most often will come up when the spouse that we're representing is either incapacitated mentally or physically, and they aren't able to adequately represent certain things to the court. So they will have either a family or a relative, somebody that doesn't have an interest in a divorce or is a beneficiary, so there's no conflict.
So now I'm regretting a little bit because we just did a video on how to get dragged into somebody else's divorce. And this is a perfect example that I didn't even mention. And that is like having a durable power of attorney. And what I mean by that, Iraj, what are some of the things that the durable power of attorney will be doing in the divorce case?
Yeah, so one of the things that we've done in the past is, let's say we want to draft an agreement. A lot of times you will need to have that agent to also sign on behalf of the spouse who's incapacitated, or even file some pleadings against to defend certain issues or allegations.
And they don't get to escape discovery, do they, Rich?
No, they don't. Financial disclosure is a big part of the divorce process, and it's everybody's most unliked part. But if that person has a power of attorney and access to all the financial institutions for the spouse, then they have the ability to hand them over. So they're also privy to that.
Good stuff. All right. I think we're going to talk about a topic we mentioned before, but we're going to mention again. Isela, is there anything that you can tell the audience about what other protections the law has in place for any spouse who tries to disinherit or kind of make sure that their current spouse or their children don't get any rights to their property?
This one is a good one for spouses that need protection. It's called the elective share. That means that your spouse can try to leave everything to someone else, but if you're legally married after they pass away, you are entitled to 30% of their elective estate. So you're entitled to 30% of what they have. But you have to make that election. You have to file paperwork with the court that you're choosing that election. So it might not benefit you, because if they're leaving, you have to calculate. If they're leaving you something that's worth more than that 30%, then it's not worth it. But if they're disinheriting you completely, you're entitled to that 30%.
That's awesome.
Yes.
Okay, and Rich, as Isela had briefly mentioned, prenup's the way to go if you want to circumvent this particular right or estate rights.
Yes, that's correct. Prenups, postnups, and a lot of times even in our marital settlement agreements, we will include some language in there that you're waiving any kind of elective share, so that it's clear cut and there's no question as to that in the event that somebody passes before you even get a final judgment.
Good stuff. So, Isela, along the same lines of what I guess you were just talking about, tell everybody what the homestead exemption is.
The homestead exemption is what protects your home from taxes, creditors, and it also gives you tax breaks. So you've noticed that your primary home is capped on how much taxes can go up, but it applies to your primary residence only, and it protects your spouse and your minor children from you. So
really? How's that? That sounds kind of contradictory.
So some people want to, maybe they get into an argument with a spouse, or they don't want to leave the house to their spouse anymore. Maybe they have a house that they owned before they got married, but now it's their primary residence where they both have resided in. It's their homestead. So they can't, in their will or trust, caveat there is a type of trust that you can do this in. You can't, in your will or trust, leave it to somebody other than your spouse. That will be what is considered a invalid device, that the court will say, nope, that's not valid. That's not how this works. That's not what the law says. These are the two options. Either share that house, meaning they can sell it and split it with your kids if there are kids, or they get a life estate, which means they can live there for their life, and then afterwards your kids get it.
It sounds like pretty cool protection for your spouse because you don't want to leave people there high and dry without anything. So it's very interesting how that plays out. Reg, is there any way around the homestead exemption?
Yeah, so although that is, a statutory right for many homestead owners, fortunately for a lot of people, one of the things that can be done are prenuptial agreements, right? And in that prenuptial agreement and or any kind of homestead waiver, one of the things that you want to make sure if you do want a waiver included is make sure that there is financial disclosure. And what does that mean? It means that usually the courts will require that with any waiver, including in a prenup, is that you need to disclose the assets and liabilities. So there needs to be a clear view on what each side has for their assets and liabilities in order to say to the court, I understood what I just signed.
Sounds good. Isela, do you think a prenup might be a way to circumvent that homestead exemption?
Yes.
Okay.
There's another type of trust called a Q-tip trust that you can also set up.
When you say Q-tip, is it like the ear cleaning device Q-tip? Is that what you're saying?
Kind of.
Instead of cleaning your ear, it cleans out your spouse.
It's qualified terminable interest property, but yeah, it is Q-tip. That's what they spell out. That one also helps with the elective share, but the postnup and the prenup are the way to do it if you want to make sure that your home does not go to your spouse. They need to waive that.
Sounds good. All right. So another very interesting topic is the good old life insurance policies. This one could be a controversial one. How do life insurance policies work, Isela?
The life insurance policy exists outside of probate. That means that if you die and you properly put in someone in there, if you put someone in there and they're still alive, that person's going to get whatever you leave them outside of the court. The court does not have to get involved in that.
Unless you put it in a trust, as you told us, right? If it's in a trust, that's
unless you put it, you can put it in a trust as well. If you have minor,
we're learning.
Yeah. There was a quiz at the end, but you already passed. So like if you have minor kids, they can't be there. They can't be the people that you leave it to because they're minors. And in Florida, minors can't inherit. So the court's going to get involved, which again, that's the whole point of estate planning is to make sure that you're in control. So usually when you have kids, you'll leave that life insurance policy to the trust, and then your kids will be the beneficiaries of your trust. So they'll still get that money, but then the trust is going to decide how they get it.
Just quick question, follow-up question on that one. So let's say that you do have a life insurance policy and it is for your children and you're divorced. If you give it the life insurance proceeds to a minor child, what happens to that money?
The court is going to take that and they are going to keep it, depending on how much it is. There's a threshold. I think it's like $20,000. It's above that, which most insurances are. The court's going to keep that until they turn 18 and then they'll get it. Or they could assign a guardian, which is going to be your ex-spouse.
Oh, so that was a rough one. That's what I was trying to get you to say, because it sounds like the court might choose the ex-spouse to be the guardian. Wow, that would hurt. Okay, Reg, couple things. When it comes to family court, life insurance policies are a hot topic item. The first of which is what happens when you file for divorce? Are you allowed to change those life insurance policy beneficiaries?
Unfortunately, you cannot just automatically change it, right? A lot of times when you file for divorce, there are what we call status quo orders or standing orders that essentially tells the parties, do not change anything, everything stays the same, right? So you're not allowed to change your beneficiary or change any of those documents unless you file for relief from the court. You file a document saying, Judge, I want to change my life insurance policy for X reasons. And then at that point, once you have a court order, you're able to go ahead and modify it.
All right, so keeping in tune with the life insurance policy issue, do you find that courts require parties to get life insurance policies after the divorce case? And if so, why?
Yes, a lot of times it's something that the court will grant. And a lot of times it's really just to protect one spouse's entitlement to alimony or spousal support, or for child support obligations as well. So if there's a spouse that's required to pay a certain amount and something were to happen to that spouse when they pass, and at least they have a life insurance policy that will go ahead and sustain those obligations moving forward.
Okay. And the last follow-up question for you, Irech, which I find fascinating, is what happens to them when someone gets divorced? An example being, if one of the spouses forgets to update their life insurance policy after they get divorced, and God forbid, a couple years later, they pass away. What happens to that life insurance policy? Does that ex-spouse automatically get the proceeds?
Thankfully, this answer is different from my prior answer, right? So once a divorce is final, or you have a final judgment, there is now a default statute that was enacted in 2012 that provides that any kind of beneficiary designation to a former spouse would be void upon the divorce being finalized, which is great. But then you have to make sure that it's updated and that anything it reflects whatever is in your agreement or the final judgment.
That's good to know. So, Isela, some interesting updates by the legislature. I'm sure you've seen plenty of fights between children of a deceased spouse and their new spouse when it comes to life insurance policies or proceeds.
Yes. Horror stories, pre-2012 horror stories, where the spouse had gotten divorced, never updated it, and then passed away, leaving minors, mortgages, spouse to deal with the rest of it, and the life insurance policy went to the ex-spouse.
Tough stuff, tough stuff. Okay, so a couple more issues. What about jointly titled property? There's property, either real estate or bank account statements. What happens if a spouse passes away and there's a joint bank account?
It goes to the other spouse. So that is going to be automatic. If you have joint title over anything, it's going to the other spouse.
I assume the same thing is with real property and personal property and things of that nature.
In your deed, it will say with right of survivorship, most times if it's done correctly. So it will that with right of survivorship means if you die, it automatically goes to the person listed on there.
One of the bigger issues as a parent that I think is very important is naming a guardian for your children. Is that something that is accounted for in some of these estate planning documents, Isela?
Yes, your will, if you have a minor child, your will is going to include what happens to your minor child. I also usually always do a pre-need guardian designation for minors, which is a separate document, just in case there's nothing to go through the court. We don't need to have the will submitted. You can just submit that document. Ultimately, the court is the one that is going to say this is the guardian, but they are going to rely on that document if you have it. If you don't have it, they are going to rely on their own wisdom. So it's probably going to be next of kin, which might not be what you wanted.
Oh no, that's awful. So question to you, Isela, how does that play out? Is only one parent sufficient to pick a guardian, or do both parents need to sign off on it? How does it usually play out, at least what you've experienced?
You need to have a meeting of the minds. So if something happens to one parent, the other parent is going to be the guardian. If they both die, then the last remaining parent's will is the one that's going to control. That's going to take priority.
Interesting. Irech, have you had any experience, at least on the family court side, in which the guardian is unclear and it needs to be fixed in family court?
Yes. Specifically, we've mentioned a lot of divorce issues, but even in paternity cases as well, or when, let's say, a mother passes away and it is unclear who will take over the kids after that, right? So a lot of times if you're trying to get adjudicated as the father, who do you serve? A lot of times automatically the people that become guardians of those children, if there was no prior will or anything, will be the mother's heirs, which would be the grandparents.
So it sounds like that could get complicated. So word of wisdom, we should probably make sure that guardians are selected by the parents, right?
Yes.
Now, another topic which I find to be super important, and that is the special needs issues. There are trusts that can be made for special needs children.
Yes. Special needs trust, they're first party or third party, and that just depends on who's setting up the trust. You are going to put things in there so that you don't exceed the limits that the government has imposed for you to get benefits that are capped. So if you make over a certain amount, you won't qualify for XYZ. So these trusts, if you're setting up that trust for yourself, that would be a first party. That means that when you pass away, there is a payback provision. So whatever you took from the government, let's say if it's Medicare, then you would give that back. So the trust would pay that back up to however much is in the trust, as long as that's what was spent. If they spend more on you than what you have, that's it. They're out of luck. They don't get to come after anybody else. The third party would be, for example, you setting it up for your child. And for that, there's no payback provisions. And they can have access to whatever you leave them without disqualifying them from that benefit.
Very interesting stuff. So when do you suggest parents that have children with special needs start asking about these types of special need trusts?
As soon as possible, because you don't know when something's going to happen to you. So if something happens to you and you leave that to your child, it's going to count as part of their assets. You are going to disqualify them. There is something called a look back period. For some benefits, it's 5 years. So you're potentially costing them government help for 5 years because you didn't set up this kind of trust.
Sounds like a very important document, Isela. Irech, when it comes to special needs children in family court, can you tell the viewers about how child support sometimes can be affected by children with special needs?
Yes, so child support has very specific statutory language on how to calculate it. But some of the things that the court can consider to kind of adjust or offset what the minimum child support would be is also considering the cost of special needs children, right? Because a person that has a disability or special needs may incur specific costs or expenses that in another minimum child support amount will not be calculated. But in this scenario where there is somebody with a disability, it should be considered because it's something that both parents need to provide for the child in order to be able to develop.
Interesting stuff. So I'm glad the family court also takes into account the needs of these children. Isela, you had mentioned something on the break about the child support payments being put in a protected place as well. Can you please explain to the audience what you were telling us?
Yes. So that child support payment that Irech was talking about, you can put it in the trust so it doesn't disqualify the child for those government benefits, which are Medicaid, SSI. Those are income, like there's an income cap. So you can't make more than that or you won't qualify. So by putting it in the trust, the child still has access to it and it won't disqualify you from those benefits.
That is a great tip.
That's amazing.
Okay, Irech, I want to ask you a little bit about some of the conflict between standing orders or status quo orders and some of the estate planning documents that we have gone over with Isela. Can you please remind the audience, I know you mentioned it briefly, what are some of these standing orders and why are they important in divorce cases?
Yeah, so just to kind of do a reminder, the status quo order or a standing order is something that automatically gets placed in effect by the court when there is an initial divorce proceeding filed. And what that means is essentially everything has to stay the same, meaning the expenses that were historically paid need to continue being paid. If it was paid by a specific account, it should be continuously maintained by the account, right? If there's a life insurance policy that either designates your spouse or your children, that should also remain the same. So one of the things that you need to watch out for and how it relates to estate planning is modifying anything that needs to be modified and also letting your attorney know, right? Because unless we know that those documents exist, they still stay in effect until you actually get relief from the court.
So interesting stuff. These standing orders, they prohibit people from essentially being a jerk and leaving people stranded. But it does have an effect on some of these estate rights and some of these other things that we talked about, starting with the life insurance policy. That's a big one. So interesting stuff. Any other areas for status quo that kind of relate with estate planning? Probably the trust. How do you think it would affect a trust document? I'm not sure you could modify a trust while the case is pending either.
Well, it depends on the trust, right, Isela? There's two types of trust. So obviously, if there's a revocable trust, which Isela mentioned earlier, can be something that can be modified or revoked. However, with respect to irrevocable, that's more difficult, right? Unless there's terminology in there that is contingent on the filing of a petition for dissolution of marriage. That one will be conflicting and you won't be able to change it.
Even within revocable, it's going to depend on whether it's a joint revocable trust or an individual revocable. You can do whatever you want with yours. Once you make it joint, you and your spouse are going to have the same rights. And once you transfer property into that trust, the default assumption is that now it's joint property. So now you've tied your hands again because now you need the court to say, unless the document already said what happens if we get divorced, now you need the court to make that decision also.
Interesting food for thought. Okay, second to last part before we wrap up. What happens, Irech, if a spouse, not that anybody's wishing for this during a divorce case, of course. What if a spouse passes away in the middle of a divorce proceeding? What happens to all the stuff?
Yeah, unfortunately, unless there's agreements in place already, most oftentimes, and Isela, you can back up some of the support for this, it will go to your spouse, right? If it's marital asset or liability. I mean, just as much as the asset, as much as the liability, right? So it can be something good or bad, but they get all of it.
Well, yep. And also, I believe the marriage is dissolved at that point, right?
Automatically when they die.
If it gets dissolved, we enter into Isela's realm of estate planning, right?
Yeah. If you died or you're divorced, you haven't changed your will or trust, either because you couldn't or you didn't, whatever is on there is what goes.
I feel like that's an appropriate end to the estate planning part of the video. How important it is to prepare for all eventualities. All right, Isela, before we let you go, because we are so grateful that you gave us so much time today and explained a lot of these different concepts, give us the law firm website and your phone number so that people can reach out to you in case they want to dust off those old estate planning docs.
Yes. Yes. My website for my law firm is igslegal.com. All my info's on there, and you can actually schedule a complimentary 30-minute initial consult with me through my website. My phone number is 407-986-1176. You can text or call me. My email is info@igslegal.com. The YouTube channel and the Instagram page are Estate Planning Lady Lawyer.
Ooh,
I like that.
I like that name.
And then my Facebook's under IGS Legal. So give me a follow. If you want to sign up for my newsletter, you can do that as well on the website. That's bi-monthly, so you won't be getting spammed all the time. But yeah.
Reg Cologne, how about you? Before we sign off, any tidbits or last words of advice that I will give to you, and then I'll ask Isela the same thing before we sign off.
No, I think we wrapped it up. I think as much as we reiterated to everybody, definitely start updating everything before entering the divorce process.
All right, Isela, thank you for coming on the show. Before I officially sign off, last words of advice to all of our viewers.
Last words. If you don't have an estate plan, the state has one for you. So if you want to decide what happens, give me a call.
Yeah, do that. The state one is probably no bueno. So that is a wrap on today's awesome video about estate planning. If you know anyone that would find this information useful, have them look us up at www.segarralawfirm.com, or Isela, throw in that website again.
igslegal.com.
We have offices located in Miami, Florida, and Orlando, Florida, where both of these ladies are located. Se habla español. Do us a favor and like this video, subscribe to the Divorce Broadcast, and hopefully we will see you all soon. Thank you.